Hi, my name is Brooke Guvin from the Columbia Center on Sustainable Investment. Nice to see you all again. I'm here today with my colleagues, Lisa Johnson and Jesse Coleman, who will appear later on in this module, to talk to you about new models and approaches to international investment treaties. So we're going to talk today about different ways that an investment treaty may be able to achieve your country's objectives in its investment policy. And we wanted to set out in advance just some framing questions and ways that you might conceptualize how to think about different models and approaches to investment treaties and investment treaty policymaking. So these questions might guide some of that decision-making and discussion within your government or as you think about this module. So first, what does your country want to achieve from international investment? And what aspects or impacts of international investment does your country want to avoid? And then what are the policy tools that are available to help your country get what it wants or what you want from investment? And how do treaties in particular fit into that broader toolbox of policy options? And what do treaties do better than other tools? And what might treaties not be well suited to achieve? So then if you decide that treaties can achieve certain objectives, how can they be designed to best help your government achieve its aims? And how can it be designed to minimize the costs and the risks that come with certain kinds of investment and investment policymaking? And then what are the overall balance of costs and benefits that are struck by the various model approaches that you might be considering or that we might talk about today? And how might this balance be distributed? So between foreign investors, domestic companies, other stakeholders, and where do you want to draw those balances and place those burdens and those obligations and those benefits? So these are all the kinds of questions that might help frame the discussion we're about to have. So at CCSI, we've done quite a bit of thinking about how investment treaties and investment treaty policy can help countries achieve their broader policy framework objectives, which we often look to as a way of shorthand to the universally agreed Sustainable Development Goals. And of course, every country or many countries have more refined and more narrowly articulated development agendas to which you might also wish to refer. But in this context, you can think about investment treaties as policy tools that can be used to encourage and channel investments that promote rather than undermine your sustainable development goals, that foster rather than constrain SDG advancing governance at the national level, and that promote international cooperation to overcome collective action problems and other challenges that relate to the governance of international investment. So these three prongs we've elaborated on further in a paper that you can see in your screen. But it's sort of rethinking the role for investment treaties in policymaking and in realigning how investment treaties promote broader policy frameworks that governments have universally articulated. So why are we talking about reform and new models and different ways of looking at investment treaties? So recent data from UNCTAD shows, as you can see on your screen, that there are currently over 1,000 known ISDS claims, treaty-based claims. And this is certainly an undercount because a lot of claims are settled or are just simply not transparent. So what's interesting when you look at this data, as you can see on the other side of the screen, is that as of 2018, so just a couple of years ago, 60% of all ISDS claims that had been filed under treaties that were came into force in the 1990s or earlier. So these are very old generation treaties with extremely broad provisions and protections for investors that are being used as the basis for 60% of claims. And all but one claim had been filed under a pre-2011 treaty. So almost the last decade of treaties have seen very few, if any, claims. And it's really these older treaties that are causing a lot of, or the basis of a lot of claims. That's not to say that all new treaties are problem-free, but it does demonstrate that there does need to be a modernization of how we conceptualize investment treaty making, and there has to be an effort to deal with these older treaties that are simply no longer suited, or in particular, no longer suited for today's sustainable development objectives. So there are various multilateral treaty and ISDS reform processes that are ongoing, and this is not to discount the new models that are coming out of individual countries or bilateral efforts, which we'll talk about a little bit longer and more in this session. But from a multilateral perspective, UNCITRAL, which we've referred to a few times in this course already, UNCITRAL's Working Group 3 is currently meeting to discuss ISDS reform. So UNCITRAL has been given a broad mandate to consider concerns surrounding ISDS and to develop multilateral solutions. And the idea is that these multilateral solutions would ideally apply to existing treaties and potentially also and hopefully to future treaties. So it would be more of a coherent look at how ISDS should be reformed to address the concerns that have been universally agreed to exist with the current way that ISDS is functioning. The mandate at Working Group 3 has been interpreted as being limited to procedural and not substantive issues with ISDS and treaty provisions. So that is to say, a procedural question would be, you know, sort of the consistency and coherence of the law coming out or the decisions coming out of investment tribunals, but would not include looking into the substantive standards. So it does not include, for example, looking into the definition of fair and equitable treatment and revising that, but it could be putting into place sort of mechanisms to ensure that decision-making is more predictable for state parties. The Energy Charter Treaty is also undergoing a modernization project that's at its earlier phases. The Organization of Islamic Cooperation is advancing options to replace arbitration under its 1981 investment agreement. And these options include new dispute settlement mechanisms. And it's been reported that these are really innovative and are really thinking about ways to align this treaty with today's objectives in investment policymaking. And then I should mention the ICSID rule reform process. So ICSID is the World Bank branch of investment arbitration, and this rule reform process is actually very narrow. It's focused only on amending the ICSID arbitration rules, which govern various procedural elements of investment treaty claims within ICSID, administered by ICSID. So it's a fairly narrow reform process. So I mentioned this distinction between substance and procedure. And in practice, it can actually be, and we would assert that it is impossible to fully distinguish between the two of these things. So many procedural rules, for example, can lead to substantive benefits given to investors. Or some procedural and substantive elements of treaties really are hard to define as one or the other. So for example, treaties that focus on investment facilitation as opposed to dispute settlement, you know, putting into place an ombuds office, which we'll talk about, to deal with disputes that investors might be having or problems investors might be having in an early phase, you know, is that substantive or procedural? There's really a question as to where that falls along that line. And there's many other elements of treaties that might fall along one or the other side. So it's really difficult actually in the end to define what is purely substantive and what is purely procedural. And indeed, many countries, including at UNCITRAL, have expressed concerns with existing treaties and the ISDS mechanism that are both substantive and procedural, and have recognized that it's impossible to distinguish between these two things. So in practice, we at CCSI would assert that all elements of a treaty should really be viewed as part of a holistic document. That if you're going to go in and modernize parts of your treaty, you really need to be considering the treaty as a whole. So you've seen this diagram now a few times, but we really think it's helpful and useful to think about how a treaty is structured and the different parts of a treaty that form the whole treaty, and how you can look at each sort of bubble to achieve your objectives in different ways. So here, for example, you could have a treaty where you have very broad standards of protection. You include all of the fair and equitable treatment, indirect expropriation, umbrella clauses, but you also have very broad carve-outs. So you might have a carve-out that says, is a self-judging carve-out that the government can invoke itself to say, this is an environmental measure and it cannot be challenged by a tribunal. In that same treaty, you might want to really narrow your definitions of investor or investment to narrow them to have certain sustainability criteria. So, in that case, you would see a treaty where you would have only protection available only to investors meeting certain criteria. You would give them broad standards of protection, but you would also retain a lot of power as a country to assert exceptions to that treaty. So that's kind of one option. And as you broaden and narrow these different bubbles, you can see how you might achieve your objectives using different parts of the treaty. So this next treaty that I wanted to look at here, this might be something more like the Brazil model, which we'll talk about later on in the session. So here you might have a much broader focus on early dispute management, on investment promotion and facilitation. So really trying to address disputes with investors before, or problems that investors are facing before they rise to the level of a dispute. So putting into place committees or ombuds offices to try to give investors a place to go before they have a real problem. You might very much narrow, as Brazil has done, the dispute resolution procedures. So Brazil does not have ISDS at all. It only has state-to-state dispute settlements. So they've completely removed ISDS and have a very narrow focus on dispute settlement. And then they've also included broad investor obligations. So, investors have to meet certain criteria in order to benefit from treaty protections. So these are just some different approaches and different ways of thinking about treaties as holistic living documents that you can use, broaden and narrow different parts of treaties to achieve your government's objectives in those treaties. So I'm now going to turn turn this over to Lisa Johnson to talk more about substantive protections in treaties.
Hi, my name is Lisa, and I'm going to take over to talk about some of the substantive trends that we're seeing in investment treaties. And this is based on an annual review that my colleagues and I do as part of the yearbook on international investment law and policy. One caveat that I wanted to start with is that we are seeing significant experimentation in the treaties. I think states are becoming bolder and more innovative in terms of trying to craft treaties that reflect their objectives and experiences. And what that means is that clear trends are hard to discern, and there are kind of exceptions to any patterns that one might think that they're identifying. So I think that that's an important thing to flag, is that really states are becoming bolder and more innovative and more creative in terms of crafting their treaties. Another trend is that we do see more narrowing, clarifying, or removing of certain obligations. Generally, the fair and equitable treatment standard is accompanied by additional language, trying to more clearly express what states mean or do not mean by that standard. Indirect expropriation provisions are similarly accompanied by additional language, clarifying the scope of the provision. The non-discrimination standards, MFN and national treatment, are often clarified, narrowed, or in some cases excluded. Umbrella clauses have similarly been excluded from many modern treaties. However, we see provisions that might operate similar to umbrella clauses being incorporated within the FET clause. So for instance, states are increasingly committed to respect specific commitments made in writing or even not in writing to investors. Another thing that we're seeing, again, is a narrowing or clarification of dispute settlement provisions or ISDS, or even a removal of ISDS in some notable treaties. Another trend that we're seeing, though, is that kind of in contrast to that narrowing or that clarification, we are seeing an expansion of certain obligations on states. So one area in which I think that we can see this expansion is in the addition of obligations applying to the pre-establishment phase, so around kind of market access. And another area is in terms of restrictions on performance requirements. So these are restrictions on the tools that states can use to potentially kind of leverage investment for development, so local content and other types of measures. And I'll talk about that a little bit more. With respect to the fair and equitable treatment standard, I think what we've been seeing in recent years is three main approaches, but again with experimentation. So the first one is to exclude the fair and equitable treatment provision. So excluding it either entirely from the treaty or potentially, as is done under the new USMCA, to exclude that provision from dispute settlement from ISDS. Some treaties will do something kind of midway where that they'll have language that might be similar to an FET provision. They might say that they provide protections against denial of justice or guarantees of fundamental due process or protections against manifestly arbitrary conduct, but they won't actually use the words fair and equitable treatment. And I think the idea behind that is to avoid some of the baggage that is associated with that language. Now, just one thing to flag is that some treaties are removing that or narrowing the FET provision, but then are including separate obligations, restricting, for instance, arbitrary treatment. And that might actually wind up expanding, again, liability. So you narrow FET, but you could create an expansion of liability or exposure in other ways. Now, a second main approach is to tether FET to the minimum standard of treatment under customary international law. So in addition to this, that countries can elaborate then what they mean by that provision. So they can elaborate the burdens of proof in terms of who has the obligation to establish a rule of customary international law. They can also identify elements that they consider to be part of the minimum standard. So some states, for instance, will say that they accept that the obligation not to deny justice is a component of the customary international law minimum standard. Some states can also then identify elements that they do not consider to be part of the minimum standard of treatment. So that is a second key approach. I mean, you'll find that, for instance, in the agreements concluded by a number of Asian states, by the US, by Canada, even though Canada is now kind of has adopted different approaches with respect to the CETA. Now, another approach then is to use an autonomous standard. And in that case, the fair and equitable treatment standard is not tied to customary international law, and it is interpreted in accordance with the rules of the Vienna Convention on the Law of Treaties or other rules of interpretation specified in the BIT. Now, in some cases, that's all that the treaty parties will say, is that the states will provide fair and equitable treatment, and they won't further elaborate. And I think that was an example in a small number of treaties that we saw this past year. And it's really kind of more reflective of the old style approach. What is more common is for countries to elaborate what they consider to be and to not be encompassed within this standard, required by this standard. Now, the second key provision, substantive obligation, I think, is the expropriation standard, and I'll focus on the provisions on indirect expropriation. So here again, one approach is to exclude indirect expropriation from the treaty. Some treaties, such as the Brazilian agreements that they included, only cover direct expropriation. Another approach is to include language clarifying the meaning of indirect expropriation, and this is, again, increasingly common. Countries will add language that clarify the relevance of the police powers doctrine, instructing tribunals what to consider when determining whether there has been or hasn't been an indirect expropriation, clarifying what assets or interests may or may not be capable of being expropriated, and also specifying when or what compensation should be paid. Now, I think as these provisions are somewhat newer, more modern, and as the bulk of disputes are continuing to arise under the older treaties, experience with this clarifying language is limited. But it has produced some, I think, important insights, even though they might be cautionary. So if, for instance, you look at Bear Creek versus Peru, where it was a modern treaty with language clarifying what was and what was not meant by the indirect expropriation provision, I think you saw the tribunal apply that in a way that was not necessarily very protective of the host state's policy space. So I would recommend people to look at Bear Creek versus Peru as an example of one of the few cases that tries to examine the clarifying language that has been linked to the indirect expropriation obligation. Now, a third approach, and this is combined sometimes with the second and even the first, is to require means for domestic adjudication of expropriation claims. So some treaties will say that the state parties have an obligation to provide domestic relief and domestic claims to allege that their property has been expropriated. So here it is saying that that each state has its own obligation to create essentially a cause of action and a forum for investors to raise claims around expropriation. Now, I think an important question here, and also an FET, is just to think about what is done domestically. How does your government domestically treat issues of indirect expropriation? What are the standards? What is compensation? And should that be changed in your international treaties? And if so, how and why? Similarly with the FET obligation, what are the standards of treatment that you guarantee to your citizens and entities? And also, what are the the remedies that are provided when there is a breach? And that with that review of how you're doing things now, you can assess maybe what you want to do differently in your investment treaties, and whether or not you want to create different standards of protection for your domestic investors, domestic stakeholders, as compared to your foreign investors and foreign stakeholders. Or foreign investors, not necessarily stakeholders. So now turning to the non-discrimination standards, national treatment, and MFN. Now, I think that we are seeing some clarification here, but to me, we're still not seeing a clear delineation of the object and purpose of these provisions. There are cases that find a breach of the national treatment and MFN provisions, but they generally are not finding that there has been nationality-based discrimination against investors. So in other words, the state can be held to have violated these provisions, even if the tribunal does not find that the state has discriminated against investors on account of their nationality. So a key case to look at in this context is Bilcon versus Canada. And I think in response to some of these decisions, which arguably take a broad approach to the non-discrimination standards, state parties have attempted, I think, to further clarify the provision. So you might look at the CPTPP, and there was a drafter's note attached to that tried to indicate what the state parties liked from jurisprudence and what they did not. But I think questions remain. So I think it's important to carefully approach these provisions and try and identify what they aim to achieve. Are you trying to prevent just general discriminatory treatment that's not necessarily based on the investor's nationality? Or are you really trying to get at and prevent and redress nationality-based discrimination, intentional or de facto? So that is something to look at, and I think there's still a lack of clarity around that in the treaties and also in the case law. There's also a wide variety of approaches in terms of scheduling, approaches to exceptions to the national treatment and MFN obligations. So some states will take a wide range of exceptions, carving out certain policy areas, certain measures, certain sectors. Some states do take a lot of exceptions and reservations to this, others do not. So it's important to think about, if you are to include these obligations, especially for pre-establishment, what types of reservations and exceptions you might want to include. On MFN as an importation tool, some treaties don't address it at all. Other treaties do include language trying to prevent importation of the ISDS or other dispute settlement provisions. So they'll say that the treaty does not permit an investor to bring in a dispute settlement provision from another treaty that might be more favorable. Now, other treaties, and this is probably less commonly done, but other treaties also try to prevent importation of substantive provisions. So that means that an investor can't look at a different treaty, identify a more favorable FET provision or a more favorable expropriation provision, and try to bring that into the treaty and benefit from it. So some treaties are trying to address and prevent that. So let's move on to the next substantive obligation. So this is restrictions on performance requirements. I wanted to flag this because I think it is something important to note because it is increasingly common, as I said, both in terms of the frequency with which we're seeing these, but also the breadth and the depth of the types of obligations that are being included. So often when we see these, the obligations are multilateralized. So what I mean by this is that when there is a restriction on performance requirements, the prohibition will apply to all investments in the host country, not just investments from the other treaty partner. So potentially look at some recent agreements concluded by Canada, by the US, Canada, the US, and Japan for examples of how this is done. Now, when these are included, they often go beyond the WTO's TRIMS requirement. So they'll apply to prevent performance requirements that apply to trade and services, not just goods. So the WTO's prohibitions on performance requirements, which have existed since the mid-1990s, they are in place, but they do apply only to trade and goods. So some investment treaties expand that. Now, you'll also see kind of vague wording that hasn't really been tested in ISDS cases so far, but I think could arguably be very broad. So for instance, the treaties might prohibit requirements to use or incentivize domestic content, but they don't really say what is domestic content requirements. So it could go beyond requirements to use local goods or services and reach even other types of expenditures. So requirements, for instance, on local labor, to invest in infrastructure development, to invest in local R&D. So again, I think it's important to look at treaties prohibiting domestic content and try and understand kind of what is meant by those words. And if you're being approached to negotiate treaties prohibiting domestic content requirements, really understanding what that encompasses. Some treaties also prevent export restrictions, and I think a number of countries are interested in introducing some types of export restrictions in order to increase, for instance, or encourage domestic beneficiation of raw materials. And often we're also seeing in performance requirements restrictions measures that restrict joint venture or other local equity requirements. So those are just a few of the samples of the things that we're seeing. They're increasingly complex, increasingly detailed, and as I said, there have been few ISDS cases, so it's a little bit difficult to understand actually what that technical language means in practice. And these are, I think, really key issues to consider for links with development outcomes, because as we know and as has been said elsewhere in this course, FDI doesn't always lead to development benefits, and that you might need state intervention in order to try and kind of best harness FDI for your sustainable development objectives. So think about also kind of how these issues might relate to emerging technologies around exploitation of rare earths and other development strategies. Now, a couple of just final points. I wanted to just highlight that there are examples of, again, limiting the substantive protections and also limiting access to ISDS. The US-Mexico-Canada agreement is a good example from 2019 of how this is done. For US-Mexico, ISDS is only available now for kind of a select few causes of action: direct expropriation, national treatment, and most favored nation treatment. So that means it is no longer available for most investors and investments for fair and equitable treatment. With certain investors with investor-state contracts in a limited number of defined sectors can still use ISDS for the suite of obligations, but again, that's narrowly confined to a certain set of investors and investments. And with respect to the US-Canada relationship, where the US and Canada had been seeing a lot of claims, now ISDS between the two of them is eliminated entirely. Now, in terms of this kind of shifting gears, but something that states could do to impose some obligations on themselves, but that might also produce kind of broader welfare benefits, is to try to use the treaties to potentially prevent harmful competition for capital. So as investment is increasingly mobile, as you might have investors kind of moving operations from one jurisdiction to another, many services operations, for instance, are kind of relatively mobile, that you don't necessarily want to be in a race with your neighbors, with other jurisdictions, to attract and to keep that investment. So how do you prevent races to the bottom in terms of competitions for capital that you might be offering investors incentives, lowering tax rates, providing lower environmental or social standards in order to try and attract and keep this capital? So how can we avoid those races? There are some tools that you've seen in treaties, these non-lowering of standards provisions, but I think that there are additional tools that can be included in the agreements to, again, try and limit those competitions. But I will leave it there and not go into more detail, but if you have questions or want to discuss that further, then we can talk about that in the session. Thank you very much. And I will turn it over to Jesse to continue. Thanks.
Thanks, Lisa. As Brooke noted at the outset, my name is Jessie Coleman, and I'm a senior legal researcher at CCSI. So moving on to our next series of examples, states are increasingly including provisions that seek to reaffirm or preserve state regulatory space and flexibility. And by regulatory space and flexibility, we mean the critical ability to shape your legal framework to optimize the benefits of international investment while minimizing or avoiding the economic, social, human rights, and environmental harms that investment can cause or exacerbate. Various types of explicit and implicit references to the state's sovereign right to regulate can be found in the preambles and right to regulate provisions that have been included in recent agreements and models. General exceptions are also increasingly being included in treaties and models concluded or published over the last decade in particular, with the list of policy areas explicitly covered by these exceptions expanding in some cases. The exact wording of these provisions will shape whether and to what extent they protect host state regulatory space and flexibility. So for example, with respect to general exceptions, including a self-judging general exception with a nexus requirement that refers to measures appropriate rather than necessary to achieve public policy objectives is likely to better protect host state policy space and to reduce the discretion afforded to tribunals or to other adjudicators to review host state conduct. With respect to operative provisions that reaffirm the state's sovereign right to regulate, it's important to really consider how any limiting language might affect the effectiveness of these provisions. For example, requiring that measures not be arbitrary or discriminatory or otherwise consistent with the rest of the agreement may weaken the scope, the protective scope of these provisions. Clarifying language can be used by treaty designers to clarify the understanding of treaty provisions in existing and in future BITs. For existing BITs, states as the masters of their treaties can and should seek to shape interpretation through, for example, joint interpretations, or where those are not attainable, unilateral declarations. Recently concluded treaties and models are also increasingly referring to sustainable development and related objectives. The Switzerland-Egypt agreement, for example, includes the reference noted on the slide in its preamble. The Canada-Mongolia agreement includes a similar reference in its preamble. References in other treaties and models can be found in both preambular and operative portions of agreements, though these references are more commonly found in preambles in more recent examples and the existing stock of treaties. References to environmental obligations and standards can be found in a number of provisions, including preambles, reaffirmations of the right to regulate, non-lowering of standards provisions, and in some cases, general exceptions and provisions concerning investor responsibilities. Colombia's model BIT, for example, includes an explicit reference to measures deemed necessary to protect the environment within its general exception. Despite the clear link between investment governance and measures needed to mitigate and adapt to climate change, even recent treaties and models do not include explicit references to climate objectives and to relevant international climate-related obligations. By contrast, free trade agreements and economic partnership agreements without investor protections contain more substantial references to climate objectives and reaffirmations of multilateral agreements concerning climate. So moving on to human rights obligations and responsibilities of states and investors. A 2014 OECD study found that only 0.5% of the 2,107 treaties covered by the study, which included around 70% of the global stock of treaties at the time, referred to human rights, with most of these references being contained within the relevant agreement's preamble. Of late, references to human rights appear somewhat more frequently in recently concluded treaties and models, but the key point is that these references remain the exception rather than the rule. Provisions in recent agreements and models may refer to the human rights obligations of states or the human rights responsibilities of investors, or very rarely, the human rights obligations of investors in a binding sense. Provisions at times explicitly refer to the rights of indigenous or other protected peoples. The effectiveness of these provisions remains unclear, with the consequences of the provisions often remaining undefined and the effectiveness undermined by limiting language. One way of including investor obligations is to condition treaty protections upon compliance with certain criteria. So in other words, to limit investment treaty protections at the jurisdictional phase to investors who only meet those specific criteria. The Colombia UAE BIT, for example, limits protection to investors who have made responsible investments in accordance with host state law. Colombia's model BIT enables denial of benefits for human rights and other specific violations. Another way of including investor obligations is to include specific requirements in the treaty that must be taken into account by adjudicators. This approach can impact the outcome of a dispute during the merits phase or result in a reduction of damages or in a counterclaim. Treaty parties can also develop treaty-specific complaints mechanisms, monitoring tools, and enforcement tools. Several recent treaties include non-binding CSR provisions. A handful also include binding investor obligations, but as already noted, these are far more rare. Treaty designers should carefully consider how and where to operationalize these types of provisions, and also how these provisions may or may not influence investor conduct in the right direction. Questions to consider include, if ISDS is included in an agreement, what conditions should be incorporated as mandatory for access, merits, and damages? What should be incorporated as part of investors' consent? What impact will these provisions and processes have on third-party rights? Could the treaty incorporate private rights of action for affected third parties at home or abroad? Treaty designers can also continue to innovate far beyond the existing examples we have in order to include more flexible and responsive mechanisms and rapid response tools. States can also consider delegating monitoring and enforcement tasks or institutionalizing flexibility, monitoring, and enforcement. Under the USMCA, for example, private parties can file complaints regarding alleged breaches of some non-derogation and non-lowering of standards provisions concerning labor standards. So with that, I'll turn it back to Brooke. Thank you very much.
Hi, so I'm back again to talk about investment facilitation and then some other closing items on this topic of new models. So as I mentioned earlier, there is a new focus in a few different treaties to focus more on investment facilitation than on dispute prevention. So Brazil in particular has taken this approach in its new model cooperation an investment facilitation agreement. It's entered into a few of these, some of which are awaiting ratification in partner countries. But the idea in Brazil's model and something that other states have been looking at more is moving away from this focus on disputes and rather putting into place procedural mechanisms through the treaty that focus more on addressing at an earlier point when an investor is experiencing issues or concerns surrounding its investment or other hurdles, putting into place mechanisms that make it easier for the investor and the state to address those problems and to then hopefully promote long-term investments in a way that are beneficial to economic development. So as I mentioned, the Brazil model puts into place an ombuds office and a joint committee, a joint treaty party committee, which the treaty party committee focuses on sort of ongoing issues related to the treaty, different issues that they may want to, that the two governments may want to address under the treaty, different ways to interpret the treaty. And the ombuds office, which in the case of Brazil, I believe is the OECD's focal point, which doubles as the ombuds office under their treaties. The ombuds office is really there to help investors who have concerns or who are experiencing hurdles. And the kinds of hurdles that Brazil has heard about from their investors are those, for example, relating to visas or different sort of procedural and technical issues relating to the functioning of their investment that they can then go to the ombuds office and hopefully have those issues addressed before they really escalate into these massive problems that we see in ISDS disputes. And you could conceptualize these kind of facilitation measures as incorporating special and differential treatment, so helping to aid developing countries or put into place different ways in which developing countries may be assisted in helping to facilitate investment in a way that might be geared toward best practices and cooperation as opposed to binding international obligations. So as you're thinking about, or as governments have been thinking about implementation of treaties and different models of treaties, some of the different questions that you might want to think about are how to ensure that treaties are living instruments. So we've seen now that these older treaties from the 90s and 2000s are no longer fit for purpose. They're simply not achieving the objectives that governments had for these treaties and in many ways are undermining current objectives of sustainable development. So how do you ensure that treaties can be amended and that the state parties have greater control over how those treaties are going to be used by investors with respect to investments? And then how do you ensure that they provide the benefits that are anticipated out of the treaty and that you can adjust them as a state party if they're not providing those benefits? So this idea of evolving over time and ensuring that if you are going to enter into these very long-term and binding agreements with other governments, that you retain the ability to ensure that they appropriately and adequately evolve to continue to meet your government's needs. So this might be the area in which, we at CCSI were thinking about how to solve these kind of different collective action problems to promote positive international engagement around investment policymaking and investment and actual investments, and using treaties to try to accomplish these objectives, which is not a focus that was really given to older treaties, but is really something you're starting to see governments think more about. So there are some new approaches that governments are taking in procedural ways with respect to dispute settlement. And so you see this in newer treaties. So the first one, which we've talked a little about, the US-Mexico-Canada agreement, severely, or not severely, but very much limits access to investor-state dispute settlement to very limited numbers of investors. And even when investors can access, there have to be certain conditions met: investor-state contracts, domestic exhaustion. The US-Canada relationship after a 3-year phase-in period doesn't even have ISDS anymore. So again, the next one, state to state. You see this evolving now, where states want to exert greater control over how these treaties are being used. And in some ways, state to state may be a better way to do that. So as I mentioned, Brazil's cooperation and facilitation agreements now only have state to state. South Africa terminated all of its investment treaties a while ago, and is now relying on its national investment law, which provides for a state-to-state dispute settlement mechanism. And then I mentioned the United States now has state-to-state only between itself and Canada. And then domestic exhaustion. So sort of the idea of re-domesticating these disputes so that national courts that are, in many ways much more democratically accountable than international investment tribunals have a chance to first address and resolve the disputes that investors are having with the government. So as I mentioned, the USMCA now has a domestic exhaustion requirement of 30 or 36 months. India includes a domestic exhaustion requirement. Morocco has put this into their model. And so trying to give the opportunity to domestic courts first before allowing investors to just bypass domestic courts and go straight to international arbitration. This also, from a state perspective, allows you to anticipate disputes that might be coming down the pipeline, as opposed to simply getting hit with a notice and needing to respond in a very sort of quick fashion. So I'll talk about a little bit this investment court proposal that some of you may be familiar with, and the European Commission has been advancing this, in particular through the UNCITRAL process. It's been discussed. And their investment court proposal includes an appellate mechanism, and those two are not necessarily, would not necessarily need to be signed on together. It could be one or the other, but we'll talk about that in a minute. And then another issue related to procedural reform and sort of legitimacy of the entire ISDS system is this idea of impacted third parties. So you see, for example, in domestic courts, when you have a non-party to a dispute, domestic courts have really advanced and evolved different mechanisms to determine if that third party is significantly impacted by the dispute or the outcome of a dispute, and under what circumstances either the requested relief needs to be tailored to no longer impact the rights of a third party, the dispute needs to be placed into a different forum, the dispute can simply not be heard unless that third party is joined to the dispute. So you're starting to see these conversations around investment treaty disputes as well, particularly in areas where the rights and interests of third parties are very much tied up in the investment process and the investment dispute, and the rights and interests of third parties may really be a central part of whatever the outcome of the dispute is. So some procedural advancements or experimentation or new models have also sought to limit access to investor-state dispute settlement. So thinking about those different bubbles we have, really narrowing that and potentially expanding others to achieve your objectives. So some treaties have limited access to ISDS for certain causes of action. So for example, in the US MCA, there is no longer FET, there's no longer indirect expropriation. You can go to ISDS, but it really has to be for denials of justice, for direct expropriation, for sort of more core and established substantive protections, and lesser so for kind of the fair and equitable treatment or indirect expropriation, which the US and Mexico and Canada have decided is not suited to purpose. And I should say some sectors in the USMCA still do get FET, but it's a limited number of 6 sectors and only investors that have an investor-state contract. So again, you're seeing the definition of investor in a much more nuanced way, and which investors the United States and Mexico are permitting to access ISDS is much more curtailed than these broader definitions we saw even under NAFTA. And then some treaties are are limiting access to ISDS for certain types of investors, so either by sector or by the responsibility of the investor. The Colombian model investment agreement, for example, includes only investors that have made responsible investments. And then we see carve-outs for certain issue areas. So, you know, the CPTPP has a tobacco exemption. So challenges to tobacco regulations are simply carved out of the treaty entirely. They cannot benefit from treaty policies or from treaty protection, sorry. And then for some policy tools. So for example, some treaties put into place state-to-state filters where the two states have to have a first look at the claim and decide that it can move forward, or at least disagree as to whether it is a treaty claim, in which case it would move forward to a dispute settlement body. And then access to ISDS can be limited to some sectors or industries. So as I mentioned, the United States-Mexico relationship now does that in 6 sectors. So treaties are limiting access to ISDS by either excluding it entirely, including domestic exhaustion, including these state-to-state filters. They're including denial of benefits. So where the state can decide that it's denying benefits of the treaty to certain kinds of investors, or investors who have violated human rights or who have engaged in you know, violations of domestic law. Or another option is that currently many treaties contain advance consent to investor-state dispute settlement. One option would be to simply withhold advance consent, put the framework into place in the treaty, but then require that the state would consent to dispute settlement at the time that the investor brings a claim, and would, to the contrary, have the ability to withhold its consent and simply not allow a claim to move forward. So as I mentioned, I want to talk quickly about the investment court that's being proposed and developed through the UNCITRAL process. So this is an investment court and an appellate mechanism. So it would be a permanent body tasked, as opposed to these ad hoc arbitral tribunals that would be tasked with hearing investment disputes, similar to something you would see, you know, for example, at the World Trade Organization. Only at the WTO, of course, it's state-to-state disputes. This would still be investor-state disputes. So in this model, the substantive treaties would not change. You would simply take your existing treaties and replace the ad hoc dispute settlement mechanism with this investment court. So you know, if the concern your government has is about broad substantive standards, this may not address those concerns. It may address issues relating to, for example, arbitrator conflicts of interest. So the idea is that if you have permanent judges, they may not be in a situation where in one dispute they're on an arbitral panel, and in another they're representing investor claimants with respect to the same subject matter. So it could deal with some of these procedural elements that have become particularly considered illegitimate and problematic with respect to ISDS. It would not address all of the concerns that states have articulated about the current investment treaties or ISDS as it's currently functioning. And the idea with the investment court or the appellate mechanism is that states could agree to sign on to one, another, or one, both, or neither, depending on how they viewed these as achieving their objectives. So in the end, you could actually have a system where, you know, some treaties are still ISDS, some treaties, depending on what the treaty partners agree, would have, say, a dispute under investment court and appellate mechanism. Some would have traditional ISDS and then an appellate mechanism that would be able to review the ad hoc tribunal's decisions. So this investment court is a proposal and one that's being developed. And I would encourage all of you to follow the UNCITRAL process, if not attend it, in order to sort of influence and articulate how this would meet your objectives. And then, as we mentioned, a lot of states are seeking to expand their control over their treaties in a way that they can continue to ensure that their treaties are meeting their objectives. So some states are putting into place state-to-state dispute settlement, some domestic exhaustion. There are increasingly efforts to focus on greater state control over how their treaties are interpreted and applied to facts, and whether or not, you know, unilateral, bilateral, or multilateral treaty interpretations can be used to advance those. And I should say these are already options that under the Vienna Convention are available to governments, but just trying to make clear in treaties that these are to be given interpretive authority when tribunals later then address those treaties. So another way states are considering expanding their control would be looking at the sunset clauses. So as we've discussed, right now, these are, you know, 10, 15, 20 years, even after a treaty is terminated. So, you know, potentially that might be something that states want to look at. You know, once they terminate a treaty, do you really want the treaty protections continuing for that length of time? Or would you like to be able to terminate a treaty and walk away? And then making exit easier. So for example, right now, many treaties have a, you know, set term, but then they continue if they're not terminated. You know, why not make it the other way around? Why not have treaties have a set term and terminate unless continued? So trying to think about how the continuation of treaties and what sort of the norm would be absent state action, and how you want to control when and how your treaty continues is another way to think about investment treaty policy. So again, you know, thinking about how proposals and new proposed models might advance your policy, I'm going to leave you with some questions as we started with. So what concerns do you have, or does your country have, about your existing investment treaties, or even your model? And then when thinking about different proposals or models, either that are being generally advanced or even potentially being advanced by a negotiating partner of your country or yourself, what would a proposed model address? And then to the contrary, what would it not address? So you have these concerns. Is a new model going to be solving your problems or not? And if not, which problems would not be solved? So then the question would be, you know, could one of these models be changed in order to better solve the problems that you have with the current investment treaties or models? And then if they can be changed, you also have to consider, in addition to those benefits, what might be the costs? You know, what might be the benefits of reform, what might be the costs, and how can these be assessed and monitored, both before you enter a treaty and after the treaty is in place? You know, how do you assess and monitor to what extent this treaty is achieving your objectives? So Ecuador, a few years ago, went through a large national process evaluating its treaties and whether or not its treaties were meeting its government's objectives. So how do you put into place these monitoring systems to ensure that when you sign a treaty, it continues to be a valuable asset in your development policy? And then how does a proposed reform or a proposed change to a treaty apply to your existing treaties? So as we saw at the beginning, you know, a lot of these existing treaties are really, really the basis of a lot of claims and really need to be addressed. So to what extent are you dealing with these older treaties when you're thinking about reform? So here are my, Lisa, and Jesse's contact information. And we would, of course, welcome any of you to contact us at any time with any questions, thoughts, comments. And we hope that this lecture and module was useful to your thinking about investment treaty making and new models and investment treaty policy. Thank you so much.